All right, welcome everyone. I'm going to call the meeting of the Minnesota Sentencing Guidelines Commission to order. It is February 13th. We're actually going to take a little departure before we call the roll and everything. I just wanted to take a minute to introduce the fact that we have a new member. Marlon Mazaros is now a member of the Sentencing Commission representing the group of treatment providers, people who provide treatment or services to individuals who've been convicted of felony offenses. So we're really excited to have him. He's on vacation. He's literally returning from vacation at this moment. So someone's audio is on. So he's returning from vacation now. So he's online, but not showing himself. And I thought that while we're recovering from a couple of technical difficulties here, the rest of us could introduce ourselves to Marlon. So why don't we go around the room and give Marlon, Commissioner Mazaros, an opportunity to meet the rest of us. And then if he has the ability to and wants to, he can say something, but if he doesn't, that's also fine, because I know he's out in public right now. So Commissioner, would you start for us?
My name is Amadini Keefe, and I'm the Executive Director at the Domestic Abuse Project.
Representing?
Victims, victim survivors.
Everyone on the commission has a slot, so we'll just say that what that slot is as we go around to you.
Marlon, I don't know if you can see me, Dave Knudsen. I'm a district court judge out of Dakota County and been on for 3 years, I think, on the commission. Welcome to the commission.
Kyra Ladd, Wadena County Attorney, and I am the County Attorney Representative on the commission. Welcome.
Welcome, Marlon. I'm Catherine Middlebrook. I am the Chief Appellate Public Defender, and I'm representing the public defender members on the commission.
Greetings, I'm Michelle Larkin. I'm a judge on the Minnesota Court of Appeals representing that court on the commission.
And hi again, I'm Kelly Mitchell, and I am representing the Department of Corrections on the commission.
I'm Nate Reitz. I'm the Executive Director, so I lead the staff of the commission.
Hello, I'm Jill Payne. I'm a research staff.
Gordon Moore. I'm the Chief Justice's designee on the Sentencing Guidelines Commission. I'm an Associate Justice on the State Supreme Court.
Hey, Marlon. I'm familiar with Marlon. I worked with him before. Latanya Reeves, Probation House Representative from Hennepin County.
Welcome, Marlon. I'm Richard Fraze. I'm retired law professor from the U of M, and I'm the academic with a background in criminal justice or corrections member.
And Commissioner Mueller.
Yes, good afternoon, Marlon. My name is Brian Mueller. I'm the Chief of Police for the City of Stillwater and representing law enforcement on the commission.
And then also online is Commissioner Morin. Commissioner Morin,
can you guys hear me?
Oh, now we can. Yes, please go ahead.
Okay. I don't know if you can see me. I might be having some technical difficulties, but my name is Tim Morin, Commissioner Morin. I'm representing the individuals that were prior convicted of a felony and have substantiated or fulfilled all their obligations to society. So,
excellent. Thank you. Commissioner Mazaros, do you want to say anything?
Hello, everyone. I could only hear part of what was said. It's very choppy here. I'm excited to get to work and get to know everyone better, and probably do another round of introductions when I'm there in person next month. Because I only heard about half of what was said, and so I think I'm going to go ahead and log off of here and let you all do your business and catch up more next month when I can actually be present and functioning better. Thank you.
Well, thanks for coming. Thanks for coming. We are excited to have you on board, and we are looking forward to seeing you next month.
Thank you.
All right. How are you doing, Director Reitz? All right. Let's go ahead and take the roll when you're ready.
Okay. Okay. Roll call. Vice Chair Larkin.
Present.
Larkin present. Commissioner Fraze.
Present.
Fraze present, Commissioner Keefe. Keefe present, Commissioner Knutson.
Present.
Knutson present, Commissioner Ladd.
Present.
Ladd present, Commissioner Mazzaros. Commissioner Mazzaros absent, Commissioner Middlebrook.
Present.
Middlebrook present, Commissioner Moore.
Present.
Moore present, Commissioner Moran.
Present.
Commissioner Moran present, Commissioner Mueller.
Present.
Commissioner Mueller present, Commissioner Reeves.
Present.
Commissioner Reeves present, Commissioner Saxena. Commissioner Saxena absent, Chair Mitchell.
Here.
Chair Mitchell present. Madam Chair, there are 11 members present, 2 members absent.
With that, we do have a quorum today. The next item on the agenda is approval of the draft meeting agenda. I would entertain a motion to approve the agenda.
Moved.
Commissioner Middlebrook moves. Do we have seconds?
Second.
Commissioner Larkin seconds. And any discussion on the agenda? Hearing none, we'll go ahead and take the vote.
On the approval of the agenda, Larkin.
Yes.
Larkin, yes. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Mazzaros. Mazzaros absent, Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Moran.
Yes.
Moran, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena absent, Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item is adoption of the draft meeting minutes from January 9th, 2025. Those were sent out about a week ago, so you all should have had a chance to review them, and I would entertain a motion to approve the minutes.
So move.
Second.
Commissioner Knutson moves and Commissioner Ladd seconds. Any discussion on the minutes? Hearing none, we'll go ahead and take the vote.
To the Knutson motion to adopt the January 9th meeting minutes, Larkin.
Yes.
Larkin, yes. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Mazzaros. Mazzaros absent, Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Moore, yes. Moran.
Yes.
Moran, yes. Mueller.
Yes.
Mueller, yes. Reeves.
Yes.
Reeves, yes. Saxena. Saxena absent, Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, item 4 on the agenda is guidelines, purposes, and principles. You may recall that in the last year, we had Professor Kevin Reitz here from the University of Minnesota Law School to talk very generally about purposes and principles, and today he's going to get a little more focused with us. And I'm going to hand the floor over to Professor Reitz to take over.
Thank you, Chair Mitchell. I need to share my screen. Which looks like it's working. Okay. Well, thank you. I'm very glad to be before the commission again today. It's always an honor for me. And this presentation does stem from two earlier presentations on the model penal code and also the purposes of sentencing that are articulated in different states. I think some of the strategy in the early presentation was to bring forward some ideas that perhaps Minnesota would want to consider. But this presentation comes forward with some policy options to actually revise language in the current sentencing guidelines to reflect some of what we've talked about in the past. And to me, it would be useful at this stage of the comprehensive review to for the commission itself to have a sense of their view on these principles. And as part of the comprehensive review, this might be something you actually want to change in the language of the guidelines. Now, since there are new commissioners, Chair Mitchell asked me to present some of the background information from earlier presentations. So the research that you'll see here was all done in mid 2024, which involved a 50-state study of statements of purposes of the sentencing system with some greater attention to guideline states than the others. Now, the primary purposes of sentencing and the sentencing guidelines in Minnesota by statute and also the current guidelines text are public safety and proportionality. Most states in our research adopt some version of these as important or primary purposes of the sentencing guidelines. But the next two slides just show you in the sentencing guidelines statute, section 244.09, the legislature's language about proportionality and public safety, and then just an example of the current sentencing guidelines that mention more than once public safety and proportionality as important goals within the system. Now, aside from public safety and proportionality, there are what I call principles, which are cross-cutting principles, including things like uniformity and rationality. And the reason I call them principles is that whether you're concerned about public safety or proportionality, you want to have rationality. You want to have uniformity. Down the bottom bullet point, and no matter what you're doing, you want to pursue neutrality with respect to race, gender, social, and economic status. So the two lead purposes here are subject to the various principles stated in the statute and the guidelines. These are all taken from that official language. Now, my focus today and the options I want to bring to the Commission's attention have to do solely with public safety and the language in our current guidelines and how that compares to what some other states have done, what the Model Penal Code has done, that the Commission may want to consider as possible amendments if they seem useful. Okay. Now, on the subject of public safety, most states in our 50-state research gave some content to those words, public safety or public protection. And most states express that public safety is equated or is driven by various utilitarian goals aimed at reducing criminal behavior and victimization. That's what public safety is. And the Model Penal Code takes this view as well. And based on similar research conducted years ago, the Model Penal Code takes the view that public safety should be defined to embrace the rehabilitation of offenders, the deterrence of future offenders, incapacitation of dangerous offenders, and reintegration of ex-offenders or people who are coming back into the community, so that in all these ways, public safety is pursued. These are the means or the strategies for pursuing that. Now, if you look across the state, I'll just give you some examples. I've presented this before, but just a couple examples. Here we have an Alabama statute talking about public safety, and it says that public safety is pursued through the deterrent influence of sentences, the rehabilitation of those convicted, and their confinement when required, which is an incapacitation in the interest of public protection. Okay, so the reference is giving content to the idea of public safety. The Texas statute of the objectives of the sentencing articles is similar. Some states mention additional utilitarian goals that are subsumed within public safety, such as restorative justice, which is part of California's list. The Massachusetts sentencing guideline talks about public protection, including recidivism prevention through expanded and integrated supervision systems like probation and parole. So that these different elements of the system are pursuing in different ways a common goal. And in all the research we did of all the states in the federal system, we found only one state that defined public safety or public protection solely in terms of incarceration. And that was Oklahoma. Oklahoma defines protection of the public as a purpose of incarceration. And in the next provision in their statute says, after the interests of public protection have been addressed, other goals such as rehabilitation, et cetera, may be considered. So I'm not offering Oklahoma as a good model for Minnesota, but I think that emphasizes how common the other model is. Now, the other question that this presentation raises for the Commission's consideration is whether public safety should be defined to address unintended consequences of criminal sentences. In particular, the Model Penal Code states that the general purposes of the sentencing system include, in the subsection 4i that is sort of outlined, the purposes of the system include the avoidance of the use of sanctions that increase the likelihood the offender will engage in future criminal behavior. So this recognizes that there is much good that we can try to do in the criminal justice system, but it's possible to have unintended consequences when we overdo things or make errors in a way that actually damage the future prospects of a defendant or their future behavior. Now, a number of states have statutory or guidelines statements to this effect. In the Maine statute, that says that one of the general purposes of sentencing in that state is to minimize correctional experiences that serve to promote future criminality. In addition to affirmatively trying to reduce crime, let's make sure we're not increasing the likelihood that someone will commit future crimes. The Maryland sentencing guidelines make a reference to the potential safety and community benefit of limiting exposure to incarceration, especially for offenders who are at a low risk of recidivism. And we'll see this kind of sentiment is repeated also in Utah, that there are appropriate uses for criminal sentences, but actually increasing the risk posed by someone is not, that would be an unintended consequence. The Utah sentencing guidelines, there's more text than I'll read, but it makes a reference to research, it's not just making this up. But it says research has shown a number of things, including that incarceration can increase risk factors. This is a future criminal behavior for lower risk individuals. So part of public safety is to try not to increase risk. The Massachusetts sentencing guidelines have a variety of provisions that kind of speak to this idea. In this particular provision, Massachusetts has generally capped probation terms at a length of 3 years, and the underscored language at the end of this slide show that that commission's view that over long periods of community supervision may actually make it more difficult for the probationer to become a functioning member of society. And yeah, I think that's kind of a review. There are additional states and slides I presented earlier, but that gives you the feel of things. Now, we've talked about both of these issues before, and today I bring two possibilities to the commission that as part of the comprehensive review, revisions to the guidelines might be considered. One is the possibility that the guidelines give a definition of the meaning of public safety. There's no definition now. To include broad strategies calculated to prevent future crimes and victimizations, including things like we've seen in some of the statutes today and in the model penal code, just to give a broad statement to what public safety is and perhaps to avoid an implication or understanding of the words that Oklahoma seems to have. But this is one possibility, and the references of states that have provisions like this, including and the model penal code, are just attached to that slide. And then the other option that the commission might consider is to add to the definition or say that one element of the goal of public safety is to avoid the imposition of penalties that increase the likelihood that the offender will engage in future criminal conduct. Okay. Now, I don't know if either of these two ideas is controversial, but it may be that a full articulation in the guidelines helps structure thought for future decision-making by the commission, and perhaps may help with some of the discussions of criminal history that are coming up. So that is my presentation. Just two slides identifying the possibility of revising the guidelines to reflect ideas that we've discussed at some length in previous meetings, with some agreement expressed at those meetings. That would be different from what the current guidelines say, would be in addition to the current guidelines, but I think may flesh out what we're trying to achieve and trying to avoid.
Lots from the commission, comments, questions. Commissioner Mueller.
Yeah, thank you, Madam Chair, Commissioners. I really appreciate the work on this and the continued effort on this. In terms of just my general impression, slide one, I love that. I love the, having those 4 rehab, general deterrence, incarceration of dangerous offenders, and then the reintegration, I think is absolutely meaningful and something that we all intend for with the sentencing guidelines. I am a little hesitant on slide 2. So I'm not sure how, or goal 2 or statement 2. I'm not sure how we would define that. So that's a little bit concerning. And then, a lot of the conversation, minimize, limit, especially the low risk offenders that are low risk to recidivate versus the seriousness of the crime are the kind of questions that I'm struggling with a little bit. So I do have a little bit of concern with number 2, but number 1, I think we can all, at least I can say that I can definitely get behind, a statement like that would be integrated into this. I would want a little more conversation on slide 2. Thank you.
You want to say anything further on slide 2 or?
Oh, I think if the commission takes an interest in expressing some form of the idea in slide 2, that wordsmithing is warranted. Slide 2 doesn't reproduce or the language from the Utah sentencing guidelines, for example. So I think the way of expressing the idea is important. And it could be an issue for the commentary of the guideline, whether there are, some explanation of the intended meaning of these provisions. That's possible. And again, that would have to be carefully drafted and ultimately subject to the approval of the commission.
Mr. Moore.
Thank you, Madam Chair. Professor Braid says the concern in public safety two, the second slide here, the notion of institutionalization, that the act of incarcerating people will result in people becoming sort of inured to, a sort of a prison culture and exposure to negative things within the institution. Is that what increases the likelihood of the offender engaging in future criminal conduct, the exposure to people that have? And I'm just kind of curious as to what the thought, where the research or thought process is behind.
Right. And, much of this comes from my 15 years of work on the model penal code and in different domains, including economic penalties and community supervision terms and the number of conditions that are imposed on probationers or people released from prison. And throughout kind of all levels of punishment, there is the possibility that a sentence, let's say heavy economic penalties imposed on a defendant, may make it very hard to establish themselves as a law-abiding member of the community. Now, Minnesota, to my knowledge, is not one of the more serious offenders in terms of imposing fines and fees and obligations on offenders, but many states do. And if this were a formal statement within the sentencing guidelines or a statute or provision of the law, then that would be one way of expressing a reservation about that policy. I think Minnesota recently shortened the length of most probation terms, and possibly part of that reason was the same as expressed in Massachusetts, that putting someone on probation for very long periods of time may do more harm than good. Nationally, there is much consensus that, at least in many states, the conditions of supervision that are imposed just routinely on people go well beyond what's needed to address their needs or the risk that they put. And so this statement just alerts policymakers and allows for a discussion of, I guess, what I would call public safety benefits from sentences and possible public safety costs in sentences that aren't carefully thought through.
So the notion of penalties here is broader than just
Yes.
incarceration. We're talking about fines, fees, probation conditions, restitution,
Yes.
other things that are part of the criminal sentence.
Yeah, maybe the word penalty should be sentences, just any kind of a, sentence imposed. But that is part of the consideration that should enter. What are the benefits we're trying to achieve? What are the possible dangers that this sentence would do more harm than good?
I know one of the things as a district court judge I would hear frequently during sentencing of young people in court is that a prison sentence was likely to result in people being exposed to kind of a lifestyle and world that would enhance or decrease the likelihood of them not coming out of the facility.
Yeah, that's a very good example. And incidentally, I should say, I don't know if this is proper, but my belief is that other states pay a great amount of attention to what Minnesota does in sentencing and in sentencing guidelines. And part of what I think about the entire comprehensive review, but also this specific possibility, is that if Minnesota adopted language of this kind, that other states would take notice. I'm sure there are other states that need it more than Minnesota, but I think every sentencing system. In tech, the Robina Institute did quite a bit of work in Texas, and we found that probation services in Texas, which were locally constituted, were getting most of their annual operating budget from fees imposed on probations. And probation officers were evaluated, their performance evaluation was based on how much money they were getting out of their probationers, not what programs or assistance or so on. And, you know, that's a very stark example that wouldn't exist here.
It doesn't.
Yes,
Just
it
so
doesn't.
Just so the record is clear.
No, Minnesota is, you know, certainly one of the better states on this. New York City is, you know, a very good illustration of a probation system that doesn't do this. But I think in general, in the broader realm of criminal sentencing in different contexts and different types of sentences and different places and jurisdictions, that recognizing the possibility of public safety costs is an important sort of intellectual discipline to go through when you think about public safety policy.
Commissioner Fraze.
Thank you, Madam Chair. Just a couple of comments in support of the last two comments and unpacking some of these ideas that I guess just well, this is sort of a question and sort of a statement that Justice Moore, the ways in which sentence can be counterproductive in terms of crime control. I mean, there is this general concept of prisonization, and we think of that as well. He's hanging out in schools for crime. He's hanging out with all these antisocial people. But there's also the angle of separating people from pro-social influences from their family in particular, especially when they're in prison and harder to visit, and the longer they are, the weaker those ties may become. And then just the fact of a prison sentence has various collateral consequences in terms of an ability to get employment, to get loans, to be a suitable marriage partner, find housing. So anyway, there are many dimensions to the prisonization problem. I think Chief Mueller raised a really important point here, which is that sentencing purposes conflict. And that's why sentencing is so difficult. So if we don't want to make individual offenders worse, but sometimes there's a minimum severity required so as not to depreciate the seriousness of the offense, and to the extent that we believe in general deterrence, to not send weak messages there. And there are trade-offs. So somehow our job is to have a structure that balances those conflicting purposes. So for example, and I'm just throwing this out, but we would have to, if we wanted to define a provision like number 2 there, maybe some further guidance would say, well, you know, if it's a high severity conviction offense, that is going to limit the consideration of making this particular offender worse, even though if it's a serious crime, but the risk of committing further serious crimes is also on the table, then maybe they're more equal. If it's a risk of just, you know, some more property crimes or something, but this person has just committed a high severity crime, then maybe we have to put the balance in favor of offense severity.
Commissioner Mueller.
Last, I just want to, I feel like slide 2 speaks a lot to maybe what the challenge is to the Commissioner of Corrections. Kind of like that, you know, if we're so concerned, Professor Frey stated it, I'm not concerned about the dangerous offenders going to prison. I am concerned when their prison time ends, how do we integrate them back into society? What have we done for programming while they're in, et cetera, et cetera. I don't know that that's a purview of the Sentencing Guidelines Commission. It definitely is for the commissioner and sheriffs that run jails, et cetera. So I just throw that out.
Yeah, really, that's an interesting comment. How do folks feel if we go back to slide 1 real quick? We've had the most discussion on slide 2, but if we go back to slide 1, how are folks feeling about something like this? Like, would we want to consider defining public safety in a way? Commissioner Mueller gave a positive, a pro argument for that. What about others on the commission? Is something we might be interested in?
I speak in favor. I think it would be a good thing to do. I mean, we always throw around public safety, but we never talk about what that means, as long as it's an encompassing definition that hits on all points of that.
I also speak in favor. Thank you, Madam Chair. I speak in favor as long as you said it encompasses what the rest of the definition is, and then adding this to the additional language. So especially the including rehabilitation of the, I hate the word offender, but I get the point of it.
Well, I should say, this isn't meant to be draft language. It's just kind of raising the topic.
But I do like how this is worded.
Okay. Mayor Keith?
I also agree. I think, and we're not going to use this specific language, but knowing like what does deterrence mean exactly and what does incapacitation?
So that might be something we could put in the commentary. Okay. So, all right, well, I think there's enough interest there that we should probably work something up for a definition of public safety. I'm hearing more controversy on number 2. Any other comments on that one? Not as much right now, I'm thinking. Commissioner Reeves?
Thank you, Madam Chair. I like it, but it's going to be hard for people to determine what you mean by it. So to avoid penalties that increase the likelihood the offender will engage in future criminal activity, well, what does that mean? And so I think the commentary needs to be very clear, because I may look at that differently. I may say, well, they got 10 kids. Do you want to put them in custody? Someone else may say, well, they pay child support, so they shouldn't go in custody for anything they ever do because they're paying child support for their kid, the kid. There's many things that people can look at. There's conversations going on in community right now about looking at children as a way for the judge to say they have kids, they don't have kids. That needs to go into consideration when you're sentencing. So I feel like that's going to come up in this conversation, which might be a good conversation, but how do we parse out that?
Right.
It can be determined so broadly by everyone.
Yeah, I think the question is whether the conversation is worth having further around some drafting. Although I know that frequently prosecutors or judges will structure a disposition in a way that there's no determination of guilt, so that the whole roster of collateral consequences won't be visited on that particular defendant if he or she succeeds on a term supervision. And that's a good example of trying to kind of avoid a burdensome array of restrictions that might make life a lot harder, make a law-abiding life a lot harder in the future.
So are you talking about a stay of adjudication, for example?
Yes.
But they still give several conditions of probation
Right.
with that stay of adjudication. So if I was to look at this language and say to avoid penalties, if I put 50 conditions on someone, what does that mean? Even though stay of adjudication, are they able to comply with all those conditions? So people can interpret it differently. Am I putting too much on this person, even though they don't have a condition of guilt in court?
Okay, two last comments and then we have to move on. So Commissioner Keefe and then Commissioner Love.
I like it. I also think that it's worth a lot of the conversation. I think this is where innovation is possible, but worth exploring. But does need to have like clarity so that people know what to expect out of it.
Thank you. I don't like it, I'll just say that. Part of it for me is because the feel I get from it is that it has a sense that we're approaching the public safety aspect as it relates to the offender, as opposed to victims and the public prospectively. So this has a feel of like, we're trying to figure out how to mitigate consequences, penalties, that sort of thing for somebody. And granted, part of that is we don't want people to reoffend because that does put the public in a better place if people don't reoffend. But I'm saying that we also need to be thinking on balance about how public safety addresses the public and victims in cases when an act occurs by an offender. And I sort of feel like when I read this, to me, it seems like we're centrally focused on the offender and their behavior, which is a part of that. But I think it negates or it forgets the rest of the equation, and that's the part that I struggle with.
Yeah, just to clarify it, at least in my mind, there would be the first paragraph of slide 1, and then this would just be below that as a second, not as an alternative, but just as two sides of the same coin.
All right, food for thought. So thank you for bringing food for thought as usual, Professor Wrights. I really appreciate it.
Well, thank you for having me.
Thank you.
The next item on the agenda is MRA, and now I can't remember what it stands for, so I'm not gonna read it. The next two items in the agenda are, I just wanted the commission to be aware that this comprehensive review is not occurring in a vacuum, and that there are other big changes that are simultaneously flowing within the state of Minnesota. And so I just wanted to provide that context. This is the last time you're gonna listen a lot though, because next week we're putting you to work, or next month. So this is your time to sit back and listen and ask questions. And I'm gonna introduce my colleague from the DOC, Carly Jorgensen. I'll ask her to introduce herself and her role and then go ahead and take it away with her presentation.
Well, thank you so much, Assistant Commissioner Mitchell, for inviting me into the entire commission, for allowing me to come present just a very brief overview on the Minnesota Rehabilitation and Reinvestment Act. So as AC Mitchell indicated, my name is Carly Jorgensen. I've worked for the DOC since 2010 in a variety of capacities, most recently as an associate warden, and am currently leading some of the planning and implementation efforts related to MRRA. So I'm going to share a PowerPoint slide deck that I'm hoping you either already have access to or very soon will have access to. Given the short amount of time I have to present, I will move through the content quickly, but would be more than happy and willing to come back in a future meeting to answer questions folks may have, although I know that AC Mitchell is more than capable of addressing many questions because she has been so intimately involved in the MRRA development process. So I'm going to work to share my screen here, and then I will dive into the presentation. So, all right. Want to just make sure, are people able to see that?
Yes.
Okay.
You don't see
Perfect.
the presentation part.
Oh, it's, yeah, there we
now
go.
we do.
Now we do.
Okay. All right. Perfect. So again, my hope is that I'll be able to cover a brief overview of the law, the foundational policy elements, and then a little bit about the implementation planning that is unfolding currently. If we have any time at the end, I'll certainly answer any questions that might come up. And I know I was given 20 minutes here, so I will keep an eye on the clock and make sure that I am not overstaying my welcome. So the Minnesota Rehabilitation and Reinvestment Act passed, and we knew at the time that it passed in 2023 that it was going to take us a pretty significant amount of time to develop the policy that would really guide operationalizing this law. And so we are right now in the final stages of some policy finalization and approval, which I'll touch on here in a little bit. But at the base, MRRA is really about 4 primary components. First, individualized rehabilitation plans. Second, the opportunity for earned incentive release. Third, the opportunity for supervision abatement. And finally, justice reinvestment. So individualized rehabilitation plans are really grounded in a research-based approach to corrections, which says when we use validated assessment to guide case planning and programming participation, we have the best opportunity to reduce recidivism and help folks move further away from the system and make more pro-social choices. And so the individualized rehabilitation plan would come out of a robust assessment process that folks who are coming into our correctional facilities at St. Cloud and Shakopee would undergo during intake. It would then involve a multidisciplinary team who would, along with the incarcerated individual, collaboratively create this IRP based both on assessment results and the individual's own identification of priorities for programming and changes that they would like to make. The next piece of this then is as individuals are navigating incarceration and ideally achieving the goals outlined in their individualized rehabilitation plan, they have the opportunity to earn a reduction in their sentence and this incentive release. And again, that IRP is really going to be focused on programming that we know addresses criminogenic needs. And so as we think about earned incentive release, people have the opportunity to potentially release that 50% of their executed sentence versus the typical 2/3 serving time. And so when and if somebody is successful in earning an incentive release, the time that they have earned to release earlier than 2/3 does not get added onto their community supervision time. And so that's when we talk about that earned incentive release and sentence reduction, it really comes in the form of people potentially earning that incentive release. So you can see here up on the screen some of the programming that we know will be important for folks to be addressing if their assessment results reveal high needs in these areas, but substance use treatment, cognitive behavioral interventions, secondary and post-secondary educational opportunities, sexual offense treatment, and so really building plans that are individualized and will help people meet their goals. The statute really lays out some exclusions that are based on sentence and time. So folks who have less than 365 days to serve upon admission to Shakopee or St. Cloud, or those who are serving life sentences, indeterminate sentences, or are subject to good time, are not eligible to earn incentive release. And as the DOC and CCA teams have worked to create the earned incentive release policy, additional qualifying criteria were built in, and we'll talk about those here in just a little bit. So the next piece of MRRA focuses on incentives related to community supervision. So as people release into the community and begin serving their supervision term, they can potentially earn a shortened period of active community supervision by meeting goals in their community supervision case plan and complying with their conditions of release. And again, here, this is really going to focus on goals and targeted programming based on assessment and reassessment results, which could include things around employment, substance use or mental health services, and other things that could include education or other pro-social behaviors and activities. So supervision abatement status, again, is an inactive form of supervision. It is not an early discharge. So if folks are placed on supervision abatement status, they will still have to comply with conditions that we'll lay out here in just a bit. So the final element of MRRA then is justice reinvestment. So as folks are earning incentive release, we will capture the savings from their earlier release, and those funds will then be redistributed to 3 different areas. First, victim support and services. Second, community supervision services. And third, crime prevention and intervention initiatives and community-based correctional programs. So the allocation of funds is 50% of those reinvestment funds will go to victim services, and then 25% to community supervision, and the remaining 25% to crime prevention and intervention. So that is a basic overview of the MRRA law, and this is really the roadmap that provides a visual representation of what we anticipate this process to look like once policies have been fully implemented, and that is expected to begin in later 2025. So as incarcerated people come into St. Cloud and Shakopee, again, they go through that intake and assessment process, meet with MDT, and create their individualized rehabilitation plan. If necessary, they'll be transferred to the facilities that best support the goals that are identified in their plan. And as they successfully engage in programming and services, they have the potential to earn that incentive release. And then upon community reentry, they can, assuming they aren't ineligible, begin working toward earning compliance credits and ultimately placement on supervision abatement status before fully discharging. So I'll shift now and talk a little bit about the core policy elements, and I will begin with earned incentive release. So in addition to the time and sentence-based exclusions I covered previously, the additional exclusionary criteria for earned incentive release will be assessed at the time of preliminary review, which will take place 180 days prior to 50% of the executed sentence. If at that time someone is scoring very high risk according to the MnSTAR, if they meet criteria for placement on intensive supervised release, or if they have a current warrant or detainer or open or pending criminal case, they will be ineligible for earned incentive release. There will be 3 forms of earned incentive release credit that people will be able to accumulate during incarceration. As you can see here, recidivism reduction programming, structured activities, and notable acts. So recidivism reduction programming are programs and interventions that are either evidence-based or have been locally researched with demonstrated efficacy. So as you can see here up on this screen, earning a secondary degree, a post-secondary degree or certificate, successful completion of substance use disorder treatment or sexual offense treatment, completion of cognitive behavioral interventions, the Prison Fellowship Academy, or the employee program through MNCOR are the specific recidivism reduction programs. And you can see attached to each of those is a certain amount of earned incentive release credit. The cognitive behavioral intervention amount of credit will be based on the intensity and length of the intervention. So some of our cognitive behavioral group interventions can be completed in as few as 10 sessions, where others require 50 or more sessions to complete. And so that 60 or 90 days is based on the intervention itself. So then moving over to the other side of the screen, you'll see here the requirement for earned incentive release. So individuals who have been assessed as low risk for recidivism according to the MnSTAR will have to have successfully completed at least one of those recidivism reduction programs. Folks who are medium risk, at least 2, and folks who are high risk, at least 3. And again, the reason very high risk is not indicated here is because folks who are very high risk will not be eligible for earned incentive release. So the 2 important qualifiers here relate to treatment. If somebody is assessed as requiring residential level substance use treatment, or if somebody is assessed as requiring prison-based sexual offense treatment, they will need to successfully complete that programming during incarceration to be eligible for earned incentive release. And so those 2 pieces will factor in as people are seeking that earned incentive release. And if somebody is low risk and has both of those treatment requirements, they would have to do both of those programs to earn incentive release. So the next way that folks can accumulate credit then is through structured activities. So structured activities include a very broad range of services and interventions to include all of the recidivism reduction programs we just discussed, as well as work assignment within facilities, volunteer and staff facilitated activities that don't meet the threshold for recidivism reduction programming, visitation. It could also include individual interventions by staff. And so structured activities will work on a day-for-day basis. So you cannot accumulate more than 1 structured activity credit per day. So if I have a work assignment and then after work I have a visit, and then following that visit I attend the Enneagram Prison Project group, Although I engaged in 3 separate structured activities for that day, I would still earn 1 day of structured activity credit. And whereas with recidivism reduction programming, it is a flat rate across the board, whether you're low risk, medium risk, or high risk, you'll get the same amount of credit for recidivism reduction programming. With structured activity, there is variance based on your risk level. So individuals who are low risk at the time of preliminary review could earn 30 days of earned incentive release credit for every 90 days of structured activity. Medium risk folks could earn 30 days for every 180 days of structured activities, and high risk folks could earn 30 days of earned incentive release credit for every 360 days of structured activities. The other thing that's important to mention here is that if somebody is actively participating in a recidivism reduction program, so we'll use education as an example, for every day that somebody is attending class, they could earn structured activity credit for that, or they will earn structured activity credit for the days that they're participating in class. If they go on to complete that program by earning their secondary degree or earning a post-secondary degree or certificate, they would have received structured activity credit for all the participation days. They would also then receive the recidivism reduction program completion credit, which is that 90 days that we discussed on the previous slide. So people can accumulate both structured activity and recidivism reduction programming credit for those specific groups and services. The final category for earned incentive release credit, which we expect to be rare, is notable acts. So at the discretion of the Commissioner of Corrections, an individual could receive earned incentive release credit for a notable meritorious act or service. And this would primarily include individuals who intervene in situations in such a way that reduces significant harm, death, or destruction. And folks could earn up to 180 days of earned incentive release credit for such an act. And I also like to share this idea of notable acts is not unique to Minnesota. As the planning team was doing a national scan of other state correction systems that offer some form of good time or earned time, many of those states offer something like notable acts, meritorious acts, heroic acts. And so this came from some of those other places where this is offered and is used in those states as well. So as individuals are moving through incarceration, their preliminary earned incentive review will take place 180 days prior to 50% of the executed sentence. And that preliminary review is really going to unfold in a few different stages. So first is going to be making sure that those concrete criteria have been met. So based on your risk level, have you completed the required number of recidivism reduction programs? There will be an audit of somebody's discipline history, and the severity and frequency of misconduct will be considered. Folks will also have to submit what we're referring to as a success planner. And the success planner is essentially an MRRA workbook where people will record everything from their assessment results to accountability and harm repair related to their victims. They'll talk about goals and case plans. They'll talk about misconduct and challenges during incarceration. And that will really take a cognitive behavioral approach to what led to that choice and how they will make pro-social alternative choices in future similar situations. They'll have an opportunity to discuss reinforcement they've received for progress and change. And that success planner is really that individual's way to sort of make their case for why they believe they've earned an incentive release. In addition to those pieces, throughout the statute, there are references to victim input and notification. Victim input will be sought at the time of intake and will influence that individualized rehabilitation plan development. Victim input will again be sought prior to this earned incentive release process playing out so that victims have the opportunity to share information that may be relevant to the decision making and safety considerations they have as people are preparing for release that might inform conditions. Built into this process will also be prosecutor notification, so an opportunity for prosecutors to be aware that somebody is being reviewed for earned incentive release and the chance for them to provide information about, potentially some pending or open cases, information that wasn't available at the time of sentencing or as the case was moving through the system, that would be important for us to be aware of now. So that prosecutor notification is not part of the statute, but really came out of consultation with the County Attorneys Association. Staff observation is another critical element of this review process, and it's an opportunity for staff to highlight the observable behavior. What progress and change have they noted, or what concerns seem to be coming up? Because MRRA is about more than checking a box and completing programming and services. It's really about how people are internalizing skills and then demonstrating that throughout their daily life while incarcerated. The final element of this preliminary review would be a calculation of accumulated credit. So those 3 forms of credit would be calculated, and that if somebody is on the mark and seems like they will be moving toward that earned incentive release, that would result in a new potential projected release date. So that happens 6 months prior to that 50% mark. And then 30 days prior to that earliest possible release, an additional review takes place to make sure that individual has gone on to create an appropriate release plan with their case manager and their assigned agent, that they participated in a transitional multidisciplinary team meeting at a minimum, including their assigned agent and case manager, to talk about accomplishments during incarceration, continued needs that require intervention or services upon release, and priorities for stability upon reentry. There will be a final interim discipline audit, an additional review to make sure all program completion requirements have been met, and verification that any input received from victims, that staff observation and prosecutor information, if provided, was all reflected within the conditions of release or the release planning process. So we'll shift now into the earned compliance credit and supervision abatement element of MRRA. And statute was a bit more prescriptive here in that earned compliance credit is really a 1-month reduction of the active supervision period for every 2 months that somebody is in compliance with their conditions and the goals on their supervision case plan. So some of the same exclusions apply here to earned compliance credit and abatement as they did for earned incentive release. So folks serving life sentences, indeterminate sentence, or subject to good time will not be eligible to earn compliance credits and supervision abatement. Additionally, folks who are on a form of early release from prison, so challenge incarceration program, work release, healthy start, conditional release for folks with drug offenses, they would not be eligible to begin earning compliance credits while they're still actively participating in that early release program. But upon completion of that program and transfer to ISR or SR, they could begin accumulating those credits. And then folks who have been convicted in Minnesota but are supervised out of state, or folks who were convicted out of Minnesota and transfer in, would not be eligible for earned compliance credit and supervision abatement. There's an important notation here at the bottom. Earned compliance credit and supervision abatement and earned incentive release are 2 separate processes. So there could be situations where folks earn an incentive release and then don't go on to earn compliance credits, or vice versa, people who don't earn an incentive release and may go on to earn compliance credits and supervision abatement. So for individuals who are leaving prison, if they would be eligible for earned compliance credit and supervision abatement status, they would walk through the steps you see here on the screen. They would complete any necessary assessments and reassessments. They would participate in a transitional MDT, again with the case manager and the agent, to really set the stage for case planning in the community and important needs that should be addressed upon release, and addressing any victim safety concerns that might influence the conditions that are set. And again, the agent would use all of the information from that transitional MDT to start framing up the goals for that initial supervision case plan. So then for folks to earn these earned compliance credits, they would need to be in compliance with conditions, demonstrating meaningful progress on the goals in their supervision case plan, and have no new or pending protective orders. And that would be assessed in 2-month increments as required by the law. So transition to supervision abatement then is based on somebody's time on active supervision plus their earned compliance credits equaling their full supervision term. And so once that happens, the supervising agent would then notify the hearings and release unit to begin the process of placing that person on supervision abatement status. And as I mentioned previously, because supervision abatement status is still a form of supervision and it is not an early discharge, there will be some conditions that will apply to folks as they transition to this lower level of supervision. You can see here remaining law abiding, notifying their agent of court appearances or contact with law enforcement, remaining in the state of Minnesota unless they receive approval, keeping their agent updated as to their residence and contact information so that should any concerns arise, the agent has the ability to get in contact with the client, complying with all directives from the agent relative to any investigations that might be unfolding based on public safety concerns or potential violations of conditions. And then refraining from direct or indirect contact with folks who are deemed to be victims unless they have approval of their agent. So that was a quick overview of where we're at within the policy space. And I'm going to quickly here now touch on what implementation planning is looking like. So the MRRA policies, the earned incentive release policy is finalized, it has been approved, and it is currently available on the public policy site. So if you're interested in looking at that full policy, it can be located in the upcoming changes section of the public policy page. It is under upcoming changes because the earned incentive release policy will not go into effect until September of 2025. The earned compliance credit and supervision abatement policy is still being finalized and is very nearly there. Once approved, that policy will also be available on the public policy site. Retroactive review process will guide the ability for individuals who are currently incarcerated to receive credit for accomplishments and progress they've made thus far during their incarceration. The retroactive review process for earned incentive release will look similar to what I outlined for full earned incentive release, but there are some important differences based on how we've historically managed programming and recommendations. But the retroactive review process is nearly finalized and complete, and that interim guidance, once issued, would also be accessible on the public site. So as we think about the timeline from here moving forward, we are looking at initial piloting of the retroactive earned incentive release process to begin here in the next month or two. We're getting very close and are really preparing the Moose Lake and Shakopee correctional facilities who will be testing the early retroactive review process. That early testing will be very small and controlled to really inform any adjustments to the process that need to be made prior to scalability or prior to expansion. And it will really help us to flag any issues with scaling. That process of testing and sort of improvement will happen throughout 2025. And so folks who are incarcerated now or who become incarcerated prior to September of 2025 would be subject to this retroactive earned incentive review process. And then, as I mentioned, full policy implementation would start in late 2025. So you can see here on the screen, there is an MRRA inbox. So if you have specific questions, certainly Assistant Commissioner Mitchell, I'm sure would be happy to help direct people. Otherwise, you can reach out to this MRRA email. And then our public website has recently recorded town halls and a lot of updates and information if people have any interest in reviewing that. So let me stop sharing here, and then I think I'm probably already at or over time, but Assistant Commissioner Mitchell, is there anything else you'd like to add that I may have missed or anything I can clarify?
Oh, that was an excellent presentation, Carly. I really appreciate that. Any questions or from the commission? Everybody knows everything? Oh, Commissioner Mueller, there you go. Commissioner Mueller.
So a quick question. You said the savings in after early release, is that, so are we just assuming this is just a maybe a super naive question, that every inmate that comes in has a tag of like X amount of dollars, and then that money is appropriated, budgeted, and then that savings then gets dispersed to the victims groups and the other categories you mentioned?
Yeah, so the per diem cost associated with the days that somebody released earlier, their earned incentive release, so that number of days would be captured. And then that savings would then be redistributed once that fund accumulates some money.
And then this is just a legislative action, correct? Just informing the guidelines. We wouldn't have any role in this per se?
So there are 11 legislatively identified stakeholder groups to consult with on policy development, but we are more than happy and interested in hearing thoughts. The Minnesota Sentencing Guidelines Commission has come up in several conversations from folks asking about the impact and or intersection with MRRA and the work that is done by this group of folks. So there's nothing that you all are required to do, but we would certainly be interested in thoughts on what's being proposed, and certainly the MRRA policies will be considered enhanced policies, meaning every year we will do a really rigorous review to inform changes. And we expect that this is going to evolve quickly and over time. So as things unfold, if you would like continuous updates or if you have thoughts, please feel free to let either Assistant Commissioner Mitchell know or reach out to us, and we would be happy to have more conversation.
Great. And then lastly, just one, is this different? So we always hear that in Minnesota, you're going to serve 2/3 of your sentence based on good time. Is this different because of the proactive nature of the offender and the steps that they have to take and how they're monitored, specifically the intake process, et cetera? Is that part of it? A, and then B, I guess I would love to, see in these test cases, how do I word this? What offenses, are these all offenses, or certain dangerous offenses that are, I didn't see that are eliminated. I saw life sentences, but I didn't see some of the more dangerous victim-centered offenses that it seems like they would all kind of be eligible for this.
Really great question. So starting with your first question, MRRA is really leaning into the reality that currently everybody who comes into our correctional facilities is going to serve 2/3 of their time. Now, there are some exceptions, right? Folks can, be assigned extended incarceration for significant misconduct, but folks are serving 2/3 of their time, kind of regardless of what they're doing while they're incarcerated. So the focus on MRRA is incentivizing people to engage in the services and interventions that we know, based on the research and the literature, reduces the likelihood of them reoffending again in the future. And when you offer that kind of incentive, we believe it will significantly change people's motivation and interest in participating in those services, and offering some additional savings that can be reinvested as people earn that incentive release. And then as people move into the community, the same concept. There is a big incentive for people to work toward, versus right now, the system is really set up to say, do these things or else. This is more about do these things to earn this. And the Challenge Incarceration Program has often been cited as a really good example of this. Right now, folks often apply to participate in the Challenge Incarceration Program because it represents such a big early release for them. And I, having worked in Shakopee for many years, I've attended many CIP graduations where I hear the individuals who participate talk about, wow, I signed up just to get out early, but over these past 6 months, I have learned just such a significant amount about myself, and I've really gained some skills that will serve me well into the future. So that's really the thinking around MRRA, is taking an approach that says when we give people something to work toward, it might be a bit more motivating, and it will amplify the great work that staff are already doing with folks inside. And another time, I'd be happy to unpack some of the feedback we've gotten from incarcerated folks and community members and staff around all of that, that indicates this could be a really really great idea that results in some safety in our facilities and the community as well. So, and then yes, there are sentence-based exclusions. There are not offense-based exclusions. So folks, regardless of their offense, could be eligible to work toward these incentives unless they were given a life indeterminate or are subject to good time.
And I'm going to add to that, a person coming into serve their prison sentence doesn't have to participate in MRRA. If they choose not to, they will serve their 2/3 time. if they choose to, they have the ability to earn their way to that 50% time. But they're not going to be forced to do it either way, and the outcome is really in their hands. Commissioner Reeves, I saw first, and then Commissioner Nixon.
Thank you, Madam Chair. So my first question is, the sentence abatement, as the probation officer here, are you saying that they are going to be put on admin probation? They'll still have their time at community be put on admin. Is that correct? Or are they just working towards getting earlier release from the supervision part in community, but they're still being monitored in the background until the end of that sentence?
I can answer that one for you. It is it is like an admin caseload. So there's nothing in the law that allows shortening the sentence, shortening the full time, so they are on paper, but they're not being actively supervised, and that will go till they're off paper at the end.
That's kind of way that we can sell it to them in the community then, is you're just working toward getting admin faster, basically. Okay, and then my second question is, did you say it was online that we can look at it, or is it not available for us to look at yet? The policy.
The earned incentive release policy is available. If you go onto the public policy site under upcoming changes, if you click there, the earned incentive release policy is available. Earned compliance credit and supervision abatement policy will be posted there as soon as it's finalized and approved.
Thank you.
Absolutely.
Knudsen.
Carly, question, what's the role for the sentencing judge? You know, with the, not the parole board, but the pardons board, would send an email to the judge and say, Judge, you sentenced this offender, and what's your comments about the request for early discharge or whatever else? So there's no role for the sentencing judge, correct?
Correct. That's there is nothing in the statute related to that, and it hasn't come up yet. So right now it's the victims, the prosecutor, and then staff within the correctional facility would be providing input on that decision.
All right. Thank you very much, Carly. I really appreciate you spending the time today with us, and I'm sure we'll be having you back as things evolve.
Great. Thank you so much. I hope everyone has a great day.
Thank you.
All right, so I have a question for the commission, because we are on a timeline, you know, like for this whole year, we have a tight timeline. And we have used up a lot of our time today. We only officially have 10 minutes left for this meeting. But I think if we were willing to stay till 4:45, we could actually get through the rest of the agenda. So I'm kind of wondering how people feel. Kyra's giving me the eye. What if would people be okay with staying till 4:45? Or is the answer no? I mean, the answer can be no.
I'm okay.
Let's blow through it.
Let's blow through it. Okay. All right. So next item is I'm going to do the next presentation on Community Supervision Advisory Committee and the reforms that are going on there. Hopefully we can do this. I can't see it yet. You know what, this particular. Oh my God, I can't like find it. Let's see. Where is it? Woo, I did it. That was terrible. This is not my favorite application. Okay, so I'm going to talk about the Community Supervision Advisory Committee and some of the reforms that have happened in that space. The first question is why are there any reforms at all? And there's sort of three answers to that have to do with funding, the size of our community supervision population, and the lack of uniformity across the state in terms of standards. So I think that you all know that we use community supervision at a pretty high rate. We use prison at a pretty low rate in this state, and we use community supervision at a very high rate. So in our own report that we put out this year, we reported that in 2022, Minnesota had the 7th lowest imprisonment rate across the country, but also the 4th highest probation rate. So we really have a large population proportionally. At the same time, we don't spend a lot of money on our corrections budget comparatively. This is from 2020. And in that year, we had the smallest proportion of our general fund budget that went to corrections compared to all of the other states. Now, that's all corrections, so that's both prison and.
That little bar.
Oh,
sorry.
Yeah, sorry. I thought it sometimes it's weird in a weird way, and usually you can't see that. Yeah. So anyway, so in Minnesota, 2.5% of our general fund was spent on corrections in 2020 and that was the lowest proportion compared to other states. We also had a patchwork quilt of funding for community supervision. Prior to 2023, there were 7 different funding streams. They were all funded in different ways, different levels, different formulas. And you don't need to know what all of these things mean. Just know that it was very complex and crazy. And then we also had a lack of uniform standards, and that's because we have a unique delivery system for community supervision in Minnesota. We actually have 3 delivery systems. There's 3 types of agencies. The first one is a Community Corrections Act county. That means the county has its own corrections agency, and they're responsible for all supervision for felonies, supervised release, misdemeanors, juveniles, and all juveniles within the county. The other option is a county probation office, which means the county does have an agency, but they only do supervision for misdemeanor, gross misdemeanor, and juveniles. And the DOC does their felony supervision. And then finally, the fallback is the Department of Corrections. At the Department of Corrections, we can do all of the supervision within the county, or we can just do the felony supervision within the county. So it really depends. Here's a map. This is almost completely up to date. One county has changed delivery systems since this particular map was last made. But you can see that it's really, there's no rhyme or reason to which county is doing which type of supervision. But what it does mean is that there's a lot of bosses, there's a lot of agency heads that have different policies for how supervision is done within their county. So as a result, that meant that we were not uniform in the way that we approached doing community supervision within the state. So in 2023, there was some significant legislation that tried to move towards solving some of these problems. First of all, the legislation established an equitable funding formula for all community supervision agencies. There's one funding stream and one formula now. The state also invested an additional $43 million into that pot to provide more funding for community supervision, and also required all community supervision agencies to develop comprehensive plans for developing, implementing, and operating correctional services. Before 2023, only Community Corrections Act counties had these comprehensive plans. Now, every single county in the state has to have a plan for how they will be delivering supervision. And then finally, they established the Community Supervision Advisory Committee. The purpose of that committee is to develop and make recommendations to the commissioner on standards for probation, supervised release, and community supervision. This is the membership of the committee, and you can see the top 3 boxes include representatives from each of the 3 delivery systems. I am one of the representatives for the DOC on this committee, and I happen to be one of the co-chairs as well. We have 3 co-chairs, 1 from each delivery system. In addition to that, we have county commissioners, treatment providers, folks appointed by the Minnesota Indian Affairs Council, the chair of the statewide evidence-based practices committee, 3 people who have been supervised under any combination of the 3 delivery systems, advocates for victims of crimes, and a representative from a community-based research organization. This is sort of how our committee works. We were given a long list of things to work on. Basically, what our task is to figure out what are the essential components of community supervision that everybody should be doing across the state, and what policies should be put in place to bind everyone to doing supervision in that way. We had a lot of specific recommendations in the statute that we had to work through. So what we do as a committee is we take each of those topics, we decide whether we're going to work on it ourselves or whether there's another group out there that can help us work on that. And we assign the work out. We get the recommendations back in, we review them, we make a final recommendation to the Commissioner of Corrections. And then once we do that, the commissioner has 45 days to tell us back whether the commissioner will enact policy in line with our recommendations, or whether there's some feedback that needs to happen there. If that policy is adopted, then it becomes a requirement of the subsidy, that one single funding stream, to follow that policy. And the comprehensive plans then have to reflect compliance with those policies. So basically, the legislature put a lot of money in a single pot, that these are the strings that are attached, right? So we have to develop policy. The counties need to follow that policy, and they need to reflect that they are doing that in their comprehensive plans. So these were a couple of the major areas of work that we did last year. Last year was the first full year of the committee. We were working on developing supervision standards and policies in lines with risk, needs, and responsivity, which I will explain in just a minute. We were working on training, the topic of training, coaching, and quality assurance. I'll tell you more about that. Gender-based, culturally responsive, and trauma-informed approaches. Advising on a periodic workload study and funding, developing key metrics. I'll tell you a little bit about each one of those. So first of all, just for anyone who's not up on all the literature for community supervision, the primary, most popular model of corrections is the risk, needs, and responsivity model. So under this model, risk is the who. It refers to the likelihood of reoffending. And people who are classified as higher risk need to be given more service. People who are classified as lower risk need to be given fewer services. And in fact, if you over-supervise or over-program somebody who is low risk, you can make them worse. You can actually increase their risk to reoffend. So risk helps us hone in on who should we be spending our time with, and where should our resources be concentrated. Needs refers to what we're doing with those individuals. So it's needs really means criminogenic needs, which are those factors that lead to criminal offending, but that can also be changed through interventions. The idea here is that the programming or services that you provide, the interventions you provide, need to target those criminogenic needs to help them with behavioral change, which will in turn help them reduce their risk to reoffend. And then responsivity is how we do it. And that just basically says, you know, there's two concepts to responsivity. The first one being, we need to provide those services in a way that's responsive to the person's learning styles and abilities, and addresses the individual barriers that they might have. Like one of the barriers that didn't used to be thought of as responsivity, but is really thought of in that way now, is housing. Like, how do you do anything else if you don't have housing? That's what you're focused on every day, right? And then the other side of this is cognitive behavioral interventions are the best how. If you work on changing that person's criminal thinking, then you're going to be, they're most likely to be more successful. They have to change the way they respond to stress, to problems, to interactions with people. And if they can do that, if they can change those responses, change their behavior, then they can reduce their reoffend, reintegrate more effectively back into. So all of our policy is really focused on putting risk, needs, and responsivity into the way that we do business within community supervision across the state. So here's a couple of things that we did make policy decisions on last year. Number one, we agreed that everyone would use the LSCMI as the primary risk assessment tool. That's LSCMI just means level of service case management inventory. It's the name of a tool. So that's going to be the primary tool. I'll tell you something about that in a minute. And then we're also looking at this year, we're exploring what other tools would we recommend that people use for more specific refining the risk assessment in cases like DWI, domestic violence, or sex offenses, where you need a little bit more information to build an effective case plan. So we've set the risk tool. The next layer is we're going to be putting policy in place to require all agencies to complete either a risk screen, so maybe something short of that full assessment, or the full risk assessment on all cases that are targeted misdemeanors, gross misdemeanors, and felonies. And the reason that we want that risk to be done is so we can do the sorting. If they are high or medium risk, we really need to intervene and do something with them. If they're low risk, we can kind of leave them alone. Next policy point is implement case planning for individuals who score high or moderate risk. So we've required the risk screen or the risk assessment. If they score high or moderate, then we need to do a case plan with them, which means we're going to identify which are those criminogenic needs and what are the interventions that we are going to put in place to help them change their behavior. So those are the first pieces of the R&R model that we're putting into policy, and we're going to keep working on additional pieces in the next year. For training, coaching, and quality assurance, well, you can't do all the stuff I just said if your agents don't know how to do it. So the other policy that we'll be putting in place is a policy that requires training in evidence-based practices. On the very top there, we have a list of the specific areas that we've called out that all agents are going to be required to be trained in. And so basically, if we either need to get them trained in those skills within the first year of hire, if there's anybody who's been left behind who never got that training, we also need to get those individuals trained up. And then in addition to that, we're also going to be requiring ongoing skill training throughout the year. So they basically have to do continuing ed for POs in order to keep their skills where they need to be. In terms of gender-based, culturally responsive, and trauma-informed approaches, it's important. We do think that there needs to be some policy around this, but our group didn't quite get to the end on this one, so we have more work to do this year, and we're expecting the evidence-based, the statewide evidence-based practices committee to be coming forward with recommendations on that later this year. Workload study and the funding formula. The funding formula is in the statute, but it's not perfect. So we are about to launch a workload study so that we can really understand what the caseloads are like statewide for probation officers and what ideal caseloads might be. So we're doing some additional work to help shore up that funding formula and make sure that the funding is being doled out in the most equitable way, in the way that supports good supervision practices. And then in terms of developing key metrics, these were metrics that were actually listed in the statute. There's a requirement that the Department of Corrections start to do annual reporting on these metrics. Believe it or not, we don't really have annual reporting on probation in Minnesota. So we did some work to try to figure out which of these items do we have the data for and can start reporting on more quickly, and which of these items do we need to do some work in order to be able to mine our data, our systems to have the data to report on them. We're still really basically of that whole list, we're still struggling with being able to report on violations and revocations, outcomes of probation violations, that sort of thing.
It wasn't done before, but
No.
starting to have to do that.
Yeah, well, and part of it is because there's 87 counties with their own systems that are locally installed. So that's really why we don't have the reporting on it, but we're working on it. Oh, that was it. That was the last one. See, I told you we could go fast. Any questions on that?
This is all state funded?
This is all state funded. Yeah. How do I not share my screen?
I just.
Well, thank you so much. Other questions? I know I went fast.
Can I just say one thing?
Yeah.
So it's state, there's state funds that come, but counties, like for example, the county that I work in is 2 counties that have a community corrections. Those 2 counties contribute money as well. So the state funds some money, but they don't pay for the delivery system of the probation that's delivered in that county.
Okay.
So it's not 100% from the state.
Is
I
there
don't know if
any,
that was your question or
it
not.
was really if there's any federal pass-through dollars.
There are none.
Okay.
No. Any other questions? So anyway, the point of both of those was just to let you know, there's a lot going on. There's a lot going on. We are a slice of the pie, but there's a lot going on. And so, you know, I know that we've had a lot of discussions about some of these collateral issues that we can't control. But it's important that we know that there actually is change in other reforms that are maybe addressing some of those concerns. We'll see. All right, so thanks for indulging me in that. Next on the agenda is the executive director's report and legislative update.
I think he knows the.
Oh, comprehensive review. Sorry, I didn't see that. Comprehensive review. So, so the steering committee did meet today, and we continue to work on, last time we had brought to you the sort of buckets of offenses that we thought merited re-ranking, or the merited a second look by the commission. So we continue to look at those today. We narrowed in, we had a pretty big list. And when we started to think about the timeline, we realized it's a lot. And so we narrowed in on the offenses that are on the standard grid, because of the 3 grids that we have, that's the area that has not received much attention. We've most recently done a lot of work with drug offenses and with criminal sexual conduct offenses. So those grids are pretty solid, and they've had a lot of attention, but the standard grid itself probably hasn't changed since DWI was added in early 2000s. So we're focusing in on those, and we did, the staff created for us a really nice packet of information to provide to the commission on each of the offenses, and developed a nice process to have you start working on rankings. So we will be bringing the first grouping of offenses to the commission next meeting, and you will be put to work. Does anyone else on the steering committee want to add anything?
And that grouping will be.
Oh, do you want to describe the grouping?
Well, the first grouping is going to be felony motor vehicle operation. So basically criminal vehicular operation, criminal vehicular homicide, PWI.
CVOs. Did you say that? Okay. My ears are turning off.
Yep. So we'll do that. All of the assaults and domestic assaults will follow soon after that. Then the things like failure to register and felon in possession will follow after that. I think that's it. All right. Oh, we're on to the executive director's report and
Thank you, Madam Chair. Before I begin, if there are any members of the public who would like to make a comment, that'll be very soon. I think you're all able to raise your hand on your device that you're monitoring the meeting through. So if you would like to make a comment to the commission, now would be a good time to raise your hand, because we'll be getting to that very soon. So Madam Chair, with respect to the legislative update, I did provide a little bit of a snippet of House File 7 in the meeting materials. What really caught my eye there is that for 47 years, the Minnesota Sentencing Guidelines Commission has been operating under a legislative approval process for commission-initiated policy change, which means the commission has to submit the policy proposal to the legislature in January. the legislature has the entire session to think about it. If they don't take action to stop it, then it takes effect on August 1st. So it's a legislative override. The bill would replace this with a legislative approval process. So that it's really the reverse of what we have now, so that it would basically be a recommendation to the legislature that's submitted in January rather than a proposal. Well, I guess it's a recommendation, same thing. But the legislature would then have to enact it into law for it to take effect. So that's really different. I had originally brought this with the possibility of maybe seeing if there was any interest in the commission making a recommendation to the legislature on this part, although the House has already heard this. They heard it on Tuesday, so I took the liberty after checking with the chair and vice chair of going ahead and testifying on it. I didn't testify for or against because the commission hasn't taken a position on it. I simply pointed out, I basically told them the story of the 2016 Drug Sentencing Reform Act, which I think consensus would say wouldn't have happened. The consensus would say A was a good thing, B was a long time coming, and C would not have happened in 2016 if it hadn't been for the fact that the commission had proposed some changes that the legislature then had to respond to because of the legislative override structure. There are some other things that the commission's required to do that are also in that bill. And I will say that as of today, the Senate now has a companion for all of these provisions as well. So they're moving forward potentially. But you know, this is kind of the bipartisan year, so it has to get support from parties really. The only other thing I wanted to cover is the fact that I have an updated calendar in your meeting packets. It's the same as the old calendar, except it has an August special meeting date. So that's going to be the all-day meeting date in August. So we're gonna, unless there's an objection, we're gonna put that on the website in place of that concludes my report.
Thank you.
Madam Chair.
Commissioner Moore.
Thank you. Director Wright, have you been asked to do a fiscal note for this legislation or is it been completed?
We're still working. We don't anticipate a fiscal note for the legislative override provision, but the other provisions, yeah, we're gonna have to. There are two provisions. One would require us to, and I think, you know, we're kind of neutral on it. We just need to have the money to create the database and the personnel and the resources for it. But district judges might have an opinion. It basically requires us to have a whole lot of very specific, very judge-specific sentencing information available on a publicly accessible data dashboard, basically. So, and that's really a change from our current practice. We, you know, just because some of that needs to be contextualized. You know, some you might have judges with different caseloads. You might have counties with different caseloads, but anyway, that's that bill. And then the other one that would also require resources would be basically all the 87 county attorneys, and really that puts the burden on the county attorneys, would have to prepare reports on all their dismissals with a lot of extra information. Provide those reports to the Minnesota Sentencing Guidelines Commission. We then have to compile all those reports and report them to the legislature each year.
Commissioner Knudsen.
Isn't there some way to obtain that information now by searching the public website or our site or reports that use?
As far as dismissals or
Just general departures by judge, or find some way to find out that information.
We do departure. I mean, we do data requests. People give us data requests and we do them on an ad hoc basis right now. We don't have, I mean, this would be, you know, from a technology point of view, this would be a great thing because it'd be moving us kind of into the future of, you know, data dashboards where people can pull whatever the information they want to pull on. So, I mean, it's kind of cool from that point of view. It's just, you know, I could envision this being used, you know, by judges' political opponents or who knows, in ways that we might not anticipate. And as far as the dismissals go, a lot of that should be on the court website, but there should be dismissal filings, but there's a lot of extra information here about like, why did the prosecutor dismiss this and what was the victim? That sort of thing that is not now required in dismissal document. Those are the things that we would be reporting on. We'd have to get from all 87 counties. Honestly, the burden on the county attorneys is going to be on that.
And is it also true that we don't have access to some of that information that they're asking, and we would have to work something out with the courts in order to get NINSA's data in order to provide the reports or produce whatever they're asking for? Is that correct?
You're back on the data dashboard. I think that is pretty much our database. I mean, most of what they're talking about on the data dashboard is MSGC data. And hopefully we're involved right now in an NINSA's integration project that was previously funded. So hopefully we will have NINSA's integration soon. As far as that goes.
It does raise the question of where the appropriate place is to go for some of the data that is listed in the reports, though, because like the dismissals and pre-trial, the pre-conviction type information that they're asking us to track, I would say we are not the best place to be tracking that.
Yeah, I mean, I guess from sort of a bureaucratic agency survival point of view, the message I'm getting is the legislature trusts us and is willing to see us expand our role as a clearinghouse and information center for sentencing related data, possibly to other areas in the criminal justice system. And, if we're properly funded for that, I'm happy to take it on. It's just we have to be funded. It is a bit of mission creep, though. I'm sure that we're not just accepting all this responsibility without proper funding.
All right, I think the last item on the agenda is public input.
And Madam Chair, no one has raised their hand.
Is there anybody online who does want to make a comment today? We're not seeing anyone raising their hands. So with that, then I would, unless there's any objection, I will adjourn the meeting. See you next month.
Thanks.